Hi everyone, welcome to today's presentation on false evidence and fabrication of false evidence. It's an important chapter in BNS Bharatiya Nyaya Sanhita 2023 and the chapter name is Offences Against Public Justice. It has many sections. Today we are going to focus on the main section from 227 to 232 of Bharatiya Nyaya Sanhita. Introduction. The administration of justice is the foundation of a civilized society. For justice to prevail, every participant, the judge, witness, and parties must uphold truth and fairness. When individuals intentionally obstruct or manipulate judicial proceedings, the very integrity of justice is threatened. Offences against public justice are those acts which obstruct, hinder, or prevent the administration of justice. Justice is one of the pillars of the legal system, and any act that interferes with its fair working is an offense not only against individuals but against the state and society at large. The Bharatiya Nyaya Sanhita 2023 has replaced the Indian Penal Code 1860 but retains the essential principles regarding these offences under a dedicated chapter, Offences Against Public Justice. Purposes of the chapter. The chapter is meant to preserve the sanctity of judicial proceedings, prevent falsehood, deceit, and corruption in court processes, punish those who obstruct justice by lying, destroying evidence, or misleading courts, ensure truthful participation of witnesses, parties, and public servants. Examples of offences against public justice: giving false evidence, also known as perjury, fabricating false evidences, threatening witnesses, harboring offenders, resisting lawful arrest, destruction of evidence, etc. Under the Bharatiya Nyaya Sanhita 2023, these provisions are placed under offences against public chapters justice. This is the chapter name. The key sections are 227 to 232 deal specifically with false evidence and fabrication of evidence. False evidence and fabrication of false evidence. Definition: evidence means any statement or material presented before a court or lawful authority to prove or disprove facts in issue. When a person knowingly provides false statement or creates false materials, it amounts to perjury or fabrication. What are the essential ingredients we are looking into means judicial proceedings or injury. This means the act must be related to an official proceeding, investigation, or inquiry. False statement or evidence: the statement, document, or circumstances must be false or fabricated. Knowledge of falsity: the person must know or believe that the evidence is false. Intent: the act must be done with the intent to mislead the court or a public authority. Result: the act should be capable of misleading the decision of the court or investigation. Here I have a key titles on the sections and what is the punishment for that. This you can take a screenshot and keep it. Now the detailed study. Section 227, which deals with giving false evidence. A person gives false evidence when, being legally bound by an oath or law to state the truth, he makes a statement which he knows or believes to be false or does not believe to be true. Explanation 1. A statement may be verbal or in form, any form. This means oral, written, electronic, etc. Second, for example, saying I believe something when one does not truly believe it. I hope it's clear. There are few illustrations to explain this. For example, A falsely swears that he heard Z admit a claim. Then A gives a false evidence. Second one, A states that he believes a signature is Z's handwriting when he does not believe so. That also amount to false evidence. Third one, A truly believes a signature is Z's, but it is not false evidence, because here A truly believes a signature is Z's, but he means he doesn't have any intention, or he thinks it is Z's, so it cannot be a false evidence. The fourth one, A says I know Z was there when he knows nothing. That is false evidence, because without knowing he is making a statement here. Fifth one, A as translator certifies a false transaction as true. False evidence, because it is being a translator, he has a duty to tell the truth or transcribe it into a true essence, but he is making a false statement here. The keynotes are covered under this section is that a person must be legally bound to speak the truth. Belief as well as knowledge matter. False evidence can be oral, written, or electronic. The offense is complete the moment the false statement is made knowingly or without belief in its truth. This section is the foundation for all subsequent section on false evidence. Section 228, Fabrication of false evidence. A person fabricates false evidence when he creates false circumstance or documents or records intending that it be used in judicial proceedings to cause the court or authority to form an incorrect opinion. Even investigation directed by or under authority of a court are considered judicial proceedings. Here the explanation what are the things considered as judicial proceedings. For example, the illustration states that A falsely makes an entry in a register showing B's presence at a place intending it to be used in court. This is fabrication of evidence. Keynotes covers creation or manipulation of false material. Wider than giving false evidence includes forging documents, altering records, or staging false circumstances. The essential intent is that the fabricated evidence may appear or be used in a judicial proceedings. Applies even before a trial if the act is a part of an investigation under judicial authority. Section 229, Punishment for false evidence. The section deals with the giving false evidence, perjury, and fabricating false evidence, creating false documents or records or circumstances for use in a judicial proceedings. There are two tiers, means higher tier and lower tier. Based on the punishment it is being distinguished. Here judicial proceeding covers not only a formal court trials but also investigation preliminary to trial or inquiries by an officer deputed by a court. So even if the false evidence occurs outside the courtroom proper, if it's part of a stage of a judicial proceeding, the harsher penalty applies. This two tier I already told you, that is section 221 clause 1 and clause 2. The clause 1 where it applies means when a false evidence is given or made in a judicial proceeding like in a court or an investigation ordered by court. Seriousness, more serious, affect justice directly, and punishment will be jail up to 7 years plus fine up to 10,000. Example, A lies under a oath in court, that will covered under section 221 clause 1. Section 229 clause 2 covers when false evidence is given or made outside a judicial proceedings in private or known courts matters. Seriousness, less serious, not part of a court case, jail up to 3 years plus fine up to 5,000. A lies in a private company report. This is the example for that. It is 229 clause 2 covers this. Now section 230, giving or fabricating false evidence with intent to procure conviction of capital offense. Whoever gives or fabricates false evidence, intending or knowing it likely to cause a person to convicted of a capital offense, shall be punished with imprisonment for life or rigorous imprisonment up to 10 years and fine up to 50,000. If an innocent person is executed in consequences of such false evidence, the person giving such false evidence shall be punishable with death or above punishment. Because the keynotes here is applies only when the intended conviction is of an offense punishable with death. That means capital offenses covered in this section includes both intention and knowledge of likelihood, as I said earlier, reflects the principle that wrongful death due to perjury is equivalent to homicide. This is the point you have to remember. Serves as a grave deterrent against malicious prosecution. Now section 231, giving or fabricating false evidence with intent to procure conviction of an offense punishable with life imprisonment or greater than or equal to 7 years. This means it is not a death related offenses, but it also a punishment is more in this case. Whoever gives or fabricates a false evidence, intended or knowing it likely to cause any person to be convicted of an offense punishable with life imprisonment or imprisonment for 7 years or more, shall be punishable as the person convicted of that offense would be. Illustration tells us that A gives false evidence to convict Z of a dacoity punishable with life imprisonment. A faces the same punishment. Here overall I can say the punishment directly reflects to the offense and the punishment for that offense. So if somebody makes an false statement or creates a false document, they will face the equal punishment relating to that offense has been fixed. Key notes: punishment mirrors the offense intent to be proved by false evidence. Based on the principle of proportional liability, the gravity of perjury equals to the gravity of intended effect. This is what I said earlier. Applies when the intended offense is serious but not capital. For capital offense, the section is 230. Here, intended offenses but not a capital offenses. Complements section 230 by covering the next lower category of serious offenses. Next, section 232, threatening any person to give false evidence. Provision: whoever threatens or induces any person to give false evidence shall be punished with the same punishment as provided for giving or fabricating false evidence. Keynotes: prevents coercion or inducement to commit perjury, recognize that event attempts to corrupt justice endanger the judicial process. There are few case laws. First one, K. Karunakaran versus TV Echara Warrior 1978. The fact of the case is that in this case the issue involved the disappearance of Rajan during the emergency period. During the proceedings, it was alleged that false statements were made by a public servant before the commission of inquiry. Held, the Supreme Court observed that giving false evidence before a lawful authority amounts to perjury and strikes at the foundation of justice. The court emphasized that truth is the soul of justice, and those who make false statements intentionally under oath commit a serious offense under the law. Significance: this case highlighted the responsibility of witnesses and public officers to uphold truth before judicial authorities. Second case, Chandrika Prasad Singh versus State of Bihar. Facts: the accused had produced false document during a land dispute trial. Even though the false evidence did not affect the final judgment, the prosecution sought punishment under the provision of fabrication. The court held that the act of fabricating evidence itself constitutes the offense, irrespective of its impact on the outcome. The offense is complete when the false document is created with an intention to mislead the court. Significance: the court clarified that intention to deceive is the core element, not the success of the deceit. This point we have to remember. Third case law, Periyaswamy versus State of Tamil Nadu. Facts: the accused submitted fabricated documents in a trial to falsely implicate another person. The Madras High Court reaffirmed that fabricating false evidence is a punishable offense even if it is later discovered before use. The preparation of such document with wrongful intent is enough. Significance: this case strengthens the different effects of the law, ensuring that the falsehood in the judicial process is strictly dealt with. Other landmark cases, you can also refer to these cases also. This is the difference between evidence and fabrication of evidence. You can take a notes. Overall, the keynotes. The section is about offense against public justice. Sections from 227 to 232 cover false evidence and fabrication. Essential elements: legal obligation to speak truth, false statement or false record, knowledge or belief of falsity, intention to affect a judicial proceedings. Punishment increases with the gravity of offences. Case law confirms that intention and knowledge are crucial. BNS extends these rules to electronic evidence and threats. These are the points. Conclusion: the offense of giving or fabricating false evidence is one of the gravest offenses against public justice. It undermines the court's ability to find truth, leads to wrongful conviction or acquittals, and erodes faith in judicial process. The Bharatiya Nyaya Sanhita 2023, by replacing IPC, not only continues these protection but also modernize them to address digital records, electronic evidence, and stricter punishment for aggravated forms. In essence, these provisions upheld the principle that truth is the foundation of justice, and anyone who attempts to corrupt that truth endangers the entire system of law. Thank you.